At the beginning, I would like to thank you very much for inviting me to the project, Legal Protection of Children with Disabilities, organized by the Justice Institute within Polish-Hungarian Research Platform 2023. And I'm also very glad to participate in this wonderful conference. I'm Associate Professor of Law at the Cardinal Stefan Wyszyński University in Warsaw, and I was a coordinator in this research project. Besides me, in part one, on the result of this research, they will be speaking Professor Nora Jakab from Ferenc Mader Institute of Comparative Law in Budapest and University of Miskolc, who will be connecting with us online, Professor Wojciech Lis from the John Paul II Catholic University of Lublin, Professor Zuza Wopera from University of Miskolc, who will be online, Dr. Marta Benius from Ferenc Mader Institute of Comparative Law in person, and Dr. Zając from University of Łomża. Regardless of our conference agenda, during the time for discussion, Mr. Tomasz Jastrzębski will also share his observation with us. Mr. Tomasz Jastrzębski is an expert of State Fund for Rehabilitation of Disabled People and senior specialist at the University of Justice in Warsaw. Now let me start, because my time is limited. I would like to discuss the principle of accessibility in the implementation of the rights of children with disabilities. We have come a long way from the first vision of children's rights to the current one. I wanted to present at the beginning the roots and the path to accessibility in international law, how the concept of accessibility emerged, how it became a part of human rights, especially rights for children with disabilities. The first acts of international law neither clearly recognized their rights nor mentioned even disability among the reasons for discrimination. The development of human rights for children with disabilities is more diverse compared to children as a group in general, from care, special treatment, through the prohibition of discrimination, the right to equal treatment and integration, but integration as far as possible. That meant they were allowed to be around of other children only if they could cope with that. And sometimes it seems this thinking is still valid. Then the time came for equal opportunities and finally full inclusion and accessibility as a principle enshrined in international law. If we want to understand what type of category accessibility is, we need to go back to its roots, to the early 60s, when the first specifications regarding the adaptation and design of buildings, other facilities for people with physical impairment, elderly, appeared in the United States. The civil rights movement began to take shape, and disability advocates saw the opportunity to join forces with other minority groups to demand equal access to public spaces. Parents were at the forefront, demanding that their children be taken out of institutions and placed into school, where they could have the opportunity to engage in society, just like children who were not disabled. And in 1990, the ADA, the Americans' Disability Act, was adopted, and many countries followed this act. The approach of United Nations has also changed. The 80s were declared as decade of persons with disabilities by UN. Article 23 of the Convention on the Rights of the Child indicated that children, the disabled child, should enjoy a full and decent life in conditions which ensure active participation in the community. According to this article, states shall also ensure effective access to education, training, healthcare, and rehabilitation services, recreation opportunities in manner conducive to the fullest possible social integration. World Conference of Human Rights in Vienna was held in 1993, and the theses were formulated that all human rights are universal, indivisible, interdependent, and interconnected. And as universal, they cover persons with disabilities without any exception. As the result of Vienna conference, the standard rules on the equalization of opportunities for persons with disabilities were adopted. And since the 80s, there has also been a development of technology. And finally, accessibility was regulated in most detailed way in the Binding Act, in the Convention on the Rights of Persons with Disabilities of 2006, as one of its general principles and in the content of particular rights. Thus, the Convention impose new obligations on governments, requires the implementation of minimum standard of accessibility, and to ensure that private entities that offer facilities and services to the public consider all aspects of accessibility. State must also ensure that rapidly developing technologies are accessible for all children, and make accessibility as a central aspect of public procurement. We can analyze accessibility in various ways from the perspective of specific human rights, but we know that the common causes of disability are war, disease, and poverty, and more than 80% children live in developing countries with no access to basic services, to water and shelter. We are unable to discuss access to all rights all around the world, but from the perspective of our region, we should focus on the rights which are particularly important to developmental stage, such as education, health, family life, peer activities, sport, cultural activities. Starting with education, accessibility includes the following elements, components: universal design of buildings, playgrounds, libraries, space for recreation, sport, canteens, toilets, transport to from school and for excursions, curricula conducted in appropriate languages and formats of communication, like national sign languages, Braille, alternative script, text easy to read, augmented and alternative modes and means of communication. Appropriate teaching materials, equipment and assistive devices for children as well as for teachers with disabilities. Personal assistants, interpreters, translators, teachers and other staff prepared, trained to teach children of diverse abilities and ensure positive learning results. Accessibility is required in both public and private school at all levels and in all its aspects, in extracurricular and social activities. However, in Poland, we don't respect these provisions of CRPD, Convention on the Rights of Persons with Disabilities. We don't require accessibility from private schools, and we still have a big problem with the accessibility of public educational facilities. The right access to family life and access to social protection, families with children with disabilities, as well as with parents or other caregivers with disabilities, face higher cost of living. It means that they could need access to social protection. Support includes access to material means, such as allowances, supplies, necessary equipment. This can be special furniture or mobility devices. Various forms of services may also be needed, such as different forms of respite care for caregivers or parents, care assistance at home and daycare facilities. These services enable children to go out to the community and parents to work, also maintain healthy family environment. Another aspect, the children with disabilities want to simply live with their families, but many of them still live in long-term institutional care. Instead of that, services should be provided at home and at the local community level. Access to healthcare is an inherent right for all children and is associated with its affordability and high quality. The availability of information, financial resources, transportation, geographic distribution, and physical access to healthcare facilities must be addressed. Very often, disability is detected quite late, which deprives the child an effective treatment and rehabilitation. Health policy should ensure early detection of disability and intervention, including access to treatment and aids, rehabilitation, mobility devices, if they are needed, as I mentioned. And of course, healthcare is very important to children with disabilities, but we can't ignore the role of rest, leisure, recreation, cultural life, and the arts. They are essential to child's development, and the children with disabilities should be provided an equal access with other children to participation in these activities. But access to literary, artistic works is denied sometimes in the States by copyright law that hinder to use such works in accessible or alternative formats. Committees UN, CRC and CRPD committees recommended the signing of the Marrakesh Treaty, and Poland has already ratified this act. Next point, access to human rights institution for children. I remember Dr. Marta Benius will elaborate on this point. I can only say that whatever mechanism is chosen, it must be both independent with adequate resources and accessible for children with specific or special needs. And now, very current issue, access to assistive technologies and to artificial intelligence. They create much greater opportunities to use new technologies in creating personalized paths in education, treatment, and rehabilitation process, supporting communication and building relationships. Artificial intelligence can be used to access to information, but there are some risks. And the risk includes, for example, using artificial intelligence to make decisions by verifying competences, using incorrect criteria, and drawing incorrect conclusions based on data. The effectiveness of artificial intelligence depends on the information and data provided to the system. If the data don't reflect differences in population, but only the history of privileged groups, children with disabilities will be analyzed in relation to these inadequate characteristics. In other words, if the data set itself is discriminatory, it will be processed in a similarly discriminatory way. So artificial intelligence must take into account the existence of data gaps at this stage. And there is another risk of shifting the burden of accessibility to removing digital barriers, as it is cheaper, at the expense of other barriers, such as architectural, transport, social. And this may result in these children being pushed out of the real world into the digital one, confined to their homes or even worse, to institutions. Therefore, states should avoid relying exclusively on technology. And there are also privacy concerns. The last point, the shape of the legal system, also matters for the effectiveness of legal instruments. Legal regulations regarding the issue of accessibility are dispersed. This means that a whole range of public institutions is responsible for different areas. Some coordinating activities in this field have recently been undertaken. Push 1, the Act on ensuring accessibility to persons with specific needs. So links should be established between basic services and institutions to facilitate a smooth transition for children, like from preschool to school or between schools, or to enable them combining learning with treatment and rehabilitation, because it's obvious that the earliest accessibility services reduce the future need for support. And as conclusions, it's believed that social and legal norms in a society shape perceptions and responses to disability. They can limit or, on the contrary, they can support, strengthen the right of vulnerable groups. Accessibility is fundamentally a matter of social justice. Any shortage of access to mentioned rights excludes them from facilities and services and deprives them of future opportunities. Children are still facing barriers to the full enjoyment of their rights, and the UN Committee, CRPD, emphasizes that the barrier is not only the disability itself, but rather a combination of social, cultural, attitudinal, and physical obstacles. However, it's important to identify challenges and barriers and systematically eliminate them. And last remark, children enjoy their rights, not even or when they become adult, but gradually in a way that is appropriate to their age and development. So regulation access to various rights must also take these aspects into account. Thank you very much for your attention. And now I'm giving the voice to Professor Nora Jakab from Ferenc Medel Institute of Comparative Law in Budapest and University of Miskolc. She will be speaking about the social security of children with disability in Hungary. Please, Professor, you can start.
Thank you very much, Professor Rozewska. It's a great honor to present here, and that I've been able to be part of this research group, because this topic relating the legal protection of children with disabilities And my focus, which was the right to social security of disabled children, was a very interesting topic. And personally, I've also developed a lot during this research. And I'm sorry not being able to see you in person. I got the permission to be remote. Thank you very much. Because of my pregnancy, I'm in the 3rd trimester. So thank you very much for this. Regarding the subject, I will be very strict on the time. So I hope that I will finish in 15 minutes. You can see on the presentation that as a labor and social lawyer, I've tried to deal with this topic from this point of view and from social policy issues. First, I dealt with the situation of disabled children regarding this field, and it was clear from the literature that the right to social security is not yet a reality for many people around the world's population, because many of them has no or has only partial access to comprehensive social protection systems. It is clear that countries need to step up measures towards realizing this right. And if this is the case, then I had a question. If the world's population, and actually a great number of the world's population, has no access or has limited access to social security, then what will I experience regarding the right to social security of disabled children? Because when we look at the issue of vulnerability, what it means, of course, it has decreased. And we could say that children with disabilities are the most vulnerable in the world. And when in Hungary at the University of Miskolc, the Hungarian team made the dissemination, then one student told me that, Professor, I would like to add something, because not only children with disabilities are the most vulnerable in the world, but I think that those disabled children who has no parents and who are in institutional care. And of course, we can agree with that. After having studied the literature, the international and the national literature on the situation and on the social security situation of disabled children, it was clear that we cannot find huge literature on that, unfortunately. Of course, we have got statistics and we have got general comments and general recommendations regarding the right to social security, how to step up measures towards this right. But the reality is that the layers of this problem are not really searched. So I think it's been a very good idea in this Polish-Hungarian research group to go into deep of this problem. It was absolutely clear that we cannot separate disabled children from the families. So when we talk about the realization of this right to social security, then it's obvious that we have to think in a bigger group. We have to think in the family and what kind of support the families get. The problem is if the disabled child is not part of a family and we cannot talk about that, in that kind of sense, the social protection system general and the social security is only part of the social security system, the social protection system, then we have to speak from a broader point of view in the case of institutionalization. At present, I also dealt quite a lot with the financial side of the social security, because it was very important issue that how much the country spend on social security, and you can see that on average only 1.1% of the GDP on social protection for children, excluding health expenditures, are spent across countries and regions. all over the world, so not too many. And at this point, let me just refer to another research, which is within the Central European Academy, and you must be very familiar with it as well. When we have looked in Central Europe, including Poland, with Polish colleagues, on the sustainability of social security system. And for example, a result of this research has been that the disabled services has been improved in the last 10 years, even in Poland and in Hungary as well, and in Central Europe. So now it seems that in Central Europe, for example, it seems to be a success story regarding the sustainability issues of services delivered to disabled people, but they are mainly focused disabled pension services and not healthcare services, where disabled children would be also affected. What were the parts of my research during these very fruitful months that we carried out in the team with our colleagues? First, I looked at social rights and social security basic principles, because I had to look at the nature of these rights that we all know as lawyers, that they are very expensive rights. Of course, I made an analysis of the Convention on the Rights of the Child, and I have seen that this right is really in the focus of the convention. I also looked at other international treaties and conventions, and the CRPD was also a very important part. And I just realized that the right to social security is like a precondition for the well-being, because of course every human rights are very important, but how we live, what is the quality of our life, is really shown and mirrored by the right to social security. Then I had to look at the Hungarian approach of the social security in the fundamental law. And after that, I turned to the, I think one of the most important point of my research, which was an analysis of the social security system in general. And I have tried to find the criteria for a child sensitive and for a sort of disabled sensitive social security system. And then I have looked at the analysis of the Hungarian social security system, reflecting the criteria for the social security system in general, which can be child sensitive and which can be disabled friendly as well. And then I formulated the Lege Ferenda suggestions. I have a report here on the slides of my final report. I have been through presenting in front of the colleagues all the areas that I went through, but now I just would like to show you the last two important parts. When we look at the social security system criteria as child sensitive, and such a social security system which has sort of life cycle approach, then one can discern that it is not really the social security system, then it is in a broad sense the social protection system that we have to talk about, and social security is only part of it. But it's very important that for the well-being of disabled children, these criteria should be fulfilled according to the literature, and this is providing adequate child and maternal nutrition, access to quality basic services, as we have also heard from Professor Rozewska, addressing gender inequality, preventing discrimination and child abuse, and increasing caregivers' access to employment or income generation, which is a very important labor law issue. But of course, the special reporter for the CRPD made recommendations to states with the aim of assisting them in developing and implementing disability inclusive social protection system. And you can see the criteria of all these. And I just would like to point, for example, ensure the right of persons with disabilities to social protection is recognized. We have comprehensive and inclusive social protection system. We have got disability benefits designed for the needs of the disabled people, including disabled children, or, for example, guarantee that benefits and services offered by social protection programs are relevant, or we should refrain from adopting any retrogressive austerity measures that directly or indirectly affect the right of people with disabilities. And we could go through, but you could also read it. And we had in the literature a third focus on inclusive social protection system, what kind of elements it combines. And you can see that countries have or must adopt different tax-financed cash transfers or in-kind support, and concessions can respond directly to disability-related needs, access to healthcare, including rehabilitation assistive technology. This is a very weak point, to have adequate assistive technology as well, or even support. Support services such as personal assistance is also a very weak point, but they are crucial for the effective practice of this right. Of course, we should have a scheme which is a sort of inclusive combinations of all these recommendations. And after having this picture, it was now easier for me to have a look to the Hungarian social security system, and it is also recommended when you look in your Polish social security system, then maybe you can also draw your consequences where the disabled policy should be improved. I went through the social security services, and especially regarding those that are included in this inclusive social protection system. And you can just see, I could list benefits in cash support, I could list benefits in kind support, other forms of support relating to personal assistance, for example, and there are, of course, personal care benefits, which are also very important from the point of disabled people. And when I summarized in this social protection system in Hungary all the rights to benefit from the social security system according to the Convention on the Rights of Children, then I could see that there are many means-tested benefits in the Hungarian social security system. And you could see, and we have got only some which are insurance-based benefits. And what does it mean that we have really focused with the means-tested benefits in cash, in kind, and in personal care services, which has the message that it cannot contribute at a high level to the well-being of disabled disabled children, disabled adults, or families with disabled children, because this kind of benefits have a very low level of amount. Of course, these services are offered mainly to the families, and in terms of legislation in the area of child protection in general, the legal environment for services has 4 decades stable, and also within the social protection system, in the social services, we can find this very stable system which has not been changed very much. There is a particular shortage of foster parents, and we can see these personal care institutions are, I think, in a high need on behalf of the disabled children. It also means that when we look at the inclusive social protection criteria, this was really the pillar that I've looked at. I could see that we have got hybrid combination of benefits. Of course, we have got support and has a significant role regarding in-kind support. We also have in theory, access to healthcare, including rehabilitation and assistive technology, but support services are not provided efficiently. And it's been my Dalega Ferenda suggestions, and I'm going to finish at this point, that to have a child-sensitive social protection system, of course, we need means-tested insurance-based benefits, and of course, personal care benefits and family-friendly labor law regulation. And how we address inequality is a fundamental law issues. And of course, we need other sectoral issues. We need an effective child protection system, with which Marta Benius dealt with a lot. And we need tax and financial policy, employment policy, labor law regulation together in a holistic approach. So thank you very much for your kind attention.
Thank you very much, Professor, for your presentation and for so detailed information about Hungarian social security system. Next to speak is Professor Wojciech Lis from the John Paul II Catholic University of Lublin with his presentation on obligations of the state for families with a disabled child. Professor, please, the floor is yours.
Ladies and gentlemen, let me start by thanking you for opportunity to participate in the research. Marcinie, Pawle, thank you very much for your trust. To my friends on the research team, it was a pleasure working with you. And now to the point. Disability is inscribed in the nature of humans, although they push this throughout of their consciousness. Everyone, sooner or later, experiences his or her own limitations resulting from bodily dysfunctions caused by illnesses, accidents, or the aging process, becoming a de facto disabled person. However, while a person is able to accept disability as a consequence of the aging process, they are not be able to accept the disability of a child, especially when the disability is congenital. The birth of a child with a disability is always a difficult experience for the whole family, which is faced with the need to reorganize its previous lifestyle, to change its life plans, its hierarchy of needs and values, its attitude towards faith, and its attitude towards its environment. The main burden of a child's disability is, of course, borne by his or her parents, who have a duty of care and upbringing. The child's disability does not release the parents from their duty of care for the child's physical and spiritual development, a duty that is independent of the child's motor or intellectual ability. It is clear that the parents of a child with a disability face an enormous challenge in meeting the specific living and developmental needs of a child with a disability, unknown to the parents of a child without disabilities. Moreover, the child disability also translates into marital relations, often becoming a source of serious crises, health problems, emotional disruption, feelings of helplessness, apathy, resignation. On top of this, there are the usual everyday worries of securing a livelihood, having to reconcile work with increased caring responsibilities and limiting social life. In such situations, without support and assistance, it is extremely difficult for a family with a disabled child to cope with all these challenges. In view of unequivocally defined constitutional principles, the principle of subsidiarity, social solidarity, protection and care of marriage and the family by the state, provision of special health care for children and the disabled, assistance to parents of disabled children should be one of the basic elements of a well-thought-out, comprehensive, long-term and perspective-oriented state social policy. Since the Republic of Poland shall be the common good of all its citizens according to the Article 1 of the Constitution of the Republic of Poland, so also children with disabilities and their parents. It must also take into account the needs of those who cannot meet their justified needs on their own, with their own efforts. The primary aim of the support provided is to bring about a real improvement in the functioning of the whole family, to stabilize mutual relations, to strengthen family ties, and to enable all its members to fulfill themselves to the extent of their capabilities determined by the fact of the child's disability. However, in order to be effective support for parents of children with disabilities must be multifaceted and multidimensional, at the same time consistent and complementary. Parents of a disabled child expect first and foremost assistance in the area of rehabilitation, which provides an opportunity to minimize the child's developmental difficulties, followed by material assistance to meet the increased needs associated with the maintenance of a disabled child. It is difficult not to notice the constant deficit of financial resources on the part of most families of children with disabilities, which is mainly due to the increased need for health services and rehabilitation services. There is no doubt that material assistance increases the ability of parents of children with disabilities to provide for themselves in other areas of functioning. Such assistance includes, in particular, family allowance and supplements to family allowance, care allowance, attendance allowance and attendance benefit, one-off allowance for the birth of a disabled child, social assistance benefits, and many others to compensate for limitation resulting from disability. To this should be added the support provided by the State Fund for the Rehabilitation of Disabled Persons and the support offered by the National Health Fund. Children with disabilities and their parents are also entitled to a number of concessions, among which it is necessary to point out a concession for travel on public transport, a concession for travel on trains, an exemption from the obligation to pay the radio and television license fee, postal concessions, museum concessions, an exemption from the tax on civil law transactions for the purchase of rehabilitation equipment or a means of transport for own use. A major facilitation of reconciling care responsibilities for a child with disabilities with work is the modification of working conditions. It is clear that caring for a child with a disability requires more commitment from the parents at the expense of time spent at work. In order to reconcile caring for a child with a disability with professional activity, the possibility of working intermittent hours, flexi-time, individual work schedules, teleworking have been introduced. It is extremely important for the physical and psychological health of parents of a child with disabilities to be relieved of an excess of daily care responsibilities for a child with disabilities, which may hinder them from fulfilling their other social roles, that of spouse, parent of other children, employee, member of various communities and associations, etc. Support is therefore needed to temporarily take over some of the responsibilities of the parents of a child with disabilities, which will help them to fulfill their diverse social roles properly, but also to regenerate their physical strength and maintain their mental balance. Assistance services play an irreplaceable role here, the availability of which, however, depends on the financial possibilities of the state budget. A similar role is played by the government's respite support program, which also another carer, often a volunteer, to take over the parent's duties for a period of time, thus providing an opportunity for respite. Equally important, sometimes even more important, is non-material support, mainly emotional. This support is meant to keep the motivation of the parents of a child with disabilities at a uniformly high level, to build a sense of acceptance and care. It comes down to the transmission of positive emotions, reducing anxiety and suffering, strengthening the parents in their daily struggle with the difficulties caused by their child's disability. A similar role is played by informational support, through which parents of a child with a disability are given guidance and instructions on where to go and what to do to get a certain type of help, how to cope, what the specific disability of the child means, and what the child's needs determine. Parents of a child with a disability need to be aware of the difficulties they will have to face, what their child's capabilities and limitations are, how to organize family life so that the needs of each member are maximally met. The information should be standardized provided in an understandable way, based on the current offer of support centers for families with a child with disabilities and easily accessible. All of the above forms of support can contribute to improving the quality of life of a disabled child and his or her parents. Of course, they will not eliminate the disability itself, but they will at least contribute to alleviating the associated limitations and meeting the associated expenses. They are necessary and should be continuously improved. It should be emphasized that both the amounts received as support and the forms of support offered to families with a child with disabilities have been increased considerably over the past few years, but are still insufficient in relation to the scale of needs. While being aware of the various difficulties faced by parents of a child with a disability, without denying the increased health needs and associated costs of supporting such a child, one cannot lose sight of the accompanying dangers. Support given without interruption makes one dependent on the help of others, causes a loss of the ability to cope with one's own problems, and leads to entitlement attitudes. This has nothing to do with either the principle of solidarity or subsidiarity. Thank you very much for your kind attention. Thank you very much.
Thank you, Professor, for sharing your insight on this moving topic. Now, according to our agenda, I would like to invite Professor Zuzanna Wopera with her presentation, or without presentation, I don't know. Professor Zuzanna Wopera is connecting with us from University of Miskolc, and she will be speaking about procedural rights of children with disabilities in civil matters. Please, Professor, the floor is yours.
Thank you so much. Dear colleague, dear professor, dear participants, first of all, I would like to say sorry that I cannot be with you in person in Warsaw. I wish I could be with you, and thank you for the opportunity to join the conference online. It is really a great honor for me to share with you in the next few minutes the conclusions of my research in the field of procedural rights of children with disabilities in civil matters. As a member of the research team of legal protection of children with disabilities, I would like to say thanks for my research group leader and the member, that it was a really great pleasure for me to be the part of this group and the part of this very, very important research. It's a very serious topic. So I would like to say in advance that in this presentation, I will summarize my research results very, very briefly, but the two submitted studies contain my scientific statements and my de lege ferenda proposals in detail. So in the beginning of my research, I put forward the hypothesis that whether we look at international, including EU law, or Hungarian regulation, two fundamental principles should prevail regarding the procedural rights of children with disabilities. First, the prohibition of discrimination, and the second is the primacy of the best interest of the child. Despite all legal requirements dealing with this issue, we have to note that children with disabilities are still experiencing serious difficulties and facing barriers to the full enjoyment of the rights of participation enshrined in the Convention on the Rights of the Child. Nori talked about it. This is the CRC, hereinafter. And in the Convention on the Rights of the Person with Disabilities, this is the CRPD. My research conclusions confirm this hypothesis. My research focused on two areas. First, I examined the international and EU legal regulation of the participation rights of disabled children in civil matters. After that, in light of this, I analyzed the legal status of children with disabilities in Hungarian substantive and procedural civil law and the possibilities of their development. So let's first look at my conclusions in the first area. Children's right to participate is multifaceted. This means children's participation in all matters affecting them, such as family decisions, school and community affairs, and in civil court proceeding. The latter is called the child's right to be heard. This is crucial for the realization of children's rights and one of the basic principles of the CRC. I hope Marti, I'm sure that Marti will speak about this topic in detail. I know. So in the relevant literature, the majority of authors consider that child rights to be heard in Article 12 of the CRC to be the most significant participation right. Article 12 of the CRC introduces the fundamental principle that all children capable of forming a view are entitled to express the view and have it taken seriously. It is a right that is particularly challenging in societies where children's views tend to be largely disregarded. The challenges is far greater for children with disabilities who are widely assumed to lack the capacity or experience to make a significant contribution. The CRPD recognizes that children with disabilities are commonly denied the right to be heard. Article 7, paragraph C of the CRPD makes clear that state parties shall ensure that children with disabilities have the right to express their views freely on all matters affecting them, their views being given due weight in accordance with their age and maturity, on equal basis with other children, and to be, it's very important, and to be provided with disability appropriate assistance to realize that right. In Article 7 of the CRPD, therefore clearly absent reference to the child's capability of forming view, because it would empty the right of a child with an intellectual disability to express a view. In the following, I will summarize the international requirements in this field. A list follows. So, the procedural law situation of disabled children in civil cases is determined by the provisions of the CRC, the CRPD, and then the EU, the Charter of Fundamental Rights of the European Union. It follows from all the three legal documents that the right to be heard in the procedure must be ensured regardless of disability. It should be noted that all children are capable of expressing views. The practice of the European Court of Human Rights and the Court of Justice of the European Union have also confirmed that the right to be heard must also be ensured for disabled children, because the ability to form views cannot be linked to an age limit or intellectual capacity. It is worth noting that the CRPD and the Charter do not link the right to be heard to capability of forming views, as I mentioned earlier. Children with disabilities must be ensuring a genuine and effective opportunity to express his or her views. This wording appeared in the Brussels 2B regulation. I have no time to dealing with this regulation, but it's very important changes in this regulation. So a child with a disability is ensured the genuine and effective opportunity to express views if they receive a disability appropriate assistance to exercise it. It is the duty of the state parties or the member states under the Brussels 2B regulation to ensure this. The disabled children must also be informed that they have the right to express their views in the proceeding affecting them. Expressing views is not an obligation, just an opportunity for a disabled child. The disabled child has the right not to exercise this right. And the last the views of the disabled child must be given due weight in accordance with his maturity, his or her maturity. The Committee on the Right of the Child has provided a detailed analysis how to interpret Article 12 of CRC in their general comment, and also provided guidance on its implementation with regard to children with disabilities. Implementation of Article 12 requires recognition of non-verbal forms of communication, such as body language, facial expression, touch, sign language, play or drawing and painting, because some children use these ways to make choices, express their preferences. So, in the second part of my research, I undertook to examine the procedural rights of children with disabilities in Hungarian private law. I found that unusually in Hungarian private law, the provisions regarding the participation, hearing, to give a child an opportunity to express views in civil judicial proceeding affecting them are found on the one hand in the Civil Code and on the other hand in the Civil Procedure Code. It should be noted that important changes was made in the Civil Code when an amendment in 2022 clearly strengthened and makes more effective the child's right to express views in family law actions affecting them. Pursuant to the amendment, the court must inform the child who has sufficient understanding about the opportunity of express views in the procedure. It's important to mention that the regulation of the Civil Code guarantee every child the right to express views in the procedure affecting them and do not make difference on the basis of disability. The Civil Procedure Code took into account a strong protection of the best interest of the child as a primary consideration when defining family law procedure and developing its special regulations. In family law procedures, such as in matrimonial proceeding or in actions related to parental custody, actions related to contact, special rules apply to the representation of the child and the participation of the minor as an interested person. She is not a party, she is not a witness, it's a special procedural situation, is interested person. Civil Procedure Code contains precious procedural rules for the hearing of a minor child as an interested person in actions related to personal status, which are very forward-looking provisions of Hungarian regulation. These provisions shall also be applied in the case of hearing disabled minor as an interested person. In summary, it can be concluded that in recent years, significant progress has made in Hungarian private law in terms ensuring the opportunity for children with disabilities to express their views. In accordance with Article 12 of the CRC, the provisions of the Civil Code and the Civil Procedure Code provide the child with the opportunity to express views, with the court being obliged to notify the child of this. This notification cannot be omitted due to the fact that the child is disabled. The Hungarian procedural regulation and institutional background should develop in such a way that the disabled child is provided with disability-appropriate assistance during the procedure in order to be able to realize their participation rights in a genuine and effective way. So at last, I hope that my research in the framework of the Polish-Hungarian Research Platform contributed to the identification of regulatory problems and finding of effective legal solution for these problems. Thank you for this opportunity and thank you for your kind attention.
Thank you, Professor, for excellent lectures you gave us. Now I would like to invite Dr. Marta Benius from Ferenc Madel Institute of Comparative Law. Dr. Marta Benius is attending with us the conference in person and will be speaking child rights-based approach towards children with disabilities, the role of national human rights institutions. Thank you.
Okay, ladies and gentlemen, distinguished colleagues, good morning. My name is Marta Benius and I joined the Polish-Hungarian Research Platform from the Ferenc Madel Institute of comparative law. Firstly, let me express my gratitude to the leadership of the Institute of Justice in Poland for providing me the opportunity to be part of the research project for the second time. This year's research topic was particularly close to my heart, so it was not only an honor, but also a great involvement. A special appreciation goes to Professor Katarzyna Roszewska, the team leader of our research group, and to my team members for the fruitful work throughout the year. So the title of my today's presentation is The Child Rights-Based Approach Towards Children with Disabilities, Role of National Human Rights Institutions, which actually synthesizes the two angles that my research took throughout the year. Firstly, I looked at the nature and the existence of the child rights-based approach, both on an international level as well as on a national level. In my case, it's a Hungarian level. And in the second part, I raised the question on the necessity of establishing a specialized human rights institution that is particularly sensitive to the rights of children with disabilities and provides genuine accessibility to them. So the evidence that children with disability have exactly the same rights as children who are not affected with such condition was already mentioned by my colleagues, and it's actually an evidence for 35 years almost in universal layer of the human rights law. Nevertheless, there are approximately 240 million children in the world who live with some kind of disability. And it's not only the person that has to cope with this condition, but it's the whole society. It's a burden and an opportunity at the same time, as disability is more a result of a social interaction than the actual condition of the disabled person. So we have this 240 million children, and unfortunately the numbers show that the coping mechanism of the society needs further improvement, as currently children with disability are more likely to experience abuse than their healthy peers, are 25% less likely to attend early childhood education, 49% more likely to have never attended school, 47% more likely to be out of primary school, 33% more likely to be out of lower secondary school. They are more likely to experience multidimensional poverty and face significantly poorer health outcomes. Their institutionalization, instead of decreasing, shows unfortunate continuity. The challenges of the 21st century, such as the possible harms of digital environment, endanger all children, but children with disabilities are affected to a much, much wider extent. So to sum up, the childhood of children with disability is more endangered and at risk than the childhood of those who live without disability. I try to summarize the findings or the results of the research in 5 findings that also show a road to a possible shaping or tailoring the child rights-based approach to a national level or on the national level. Obviously, the time does not allow us to go into all findings in detail, so I will just highlight them. The first finding is that the currently available international human rights law at the universal level sufficiently cover children with disability. So children with disability, they have special needs and need special protection from 2 perspectives. Firstly, they are children, so they are entitled to a childhood that nourishes them and prepares them for full adulthood. Secondly, they have some kind of disability which makes them even more vulnerable. Both of these needs are addressed by international human rights law. One is the already mentioned, the both conventions were already mentioned by my colleagues. The one is the United Nations Convention on the Rights of the Child and the United Nations Convention on the Rights of Persons with Disability, the UNCRC and the UNCRPD. It is both common of these documents that they are very widely accepted by international community, and they represent a shift from the caring model to a rights-based model in terms of disabled person from a medicalized model to a rights-based approach, which in practice means that both of these documents put a stress on participatory rights of the target group. So with the CRC and the CRPD being there to strengthen and supplement each other, one may well-groundedly draw the conclusion that the currently available human rights framework is there to be invoked by children with disability. The devil here actually lies in good understanding on both national and international level, the implementation and the practice on national, international, and cross-border level. My next finding would be the elements of the child rights-based approach towards children with disabilities. In brief, the child rights-based approach could be defined as glasses, where the lenses needs to be changed in each and every case when we look to an individual situation of an individual child or a group of children. Nevertheless, there are elements, the principles of the UNCRC that very much shape these glasses. These principles, 4 of them are underlined by the Committee on the Rights of the Child as well, but I'd like to add always a +1 principle, what I believe very much shapes these glasses. So the principles are non-discrimination, best interest of the child, the viewpoint of the child, the right to life, survival and development, and all of this is supplemented by the right to life in a loving and caring family environment. So disability as such is an element that indeed adjusts and should be adjusting the glasses. However, in a manner that they still stay lenses and glasses of children's rights and not turn to the glasses of disability. The childhood of disabled children should always put first. It is important to also note that the child rights-based approach is not necessarily identical with the approach of the CRC or the CRPD committees, but an approach that takes into account and monitors the interpretative work of these bodies and applies it if it can be integrated and pasted into national measures. So the third finding would be that all of the elements of the child rights-based approach are injured, both from a more generalizing perspective and also from the perspective of Hungarian law. From a generalizing perspective, discrimination, explicit and hidden, is affecting children with disabilities worldwide. The best interest of the child principle is not applied comprehensively, and the voice of children is not given due weight when determining their best interest. Even though these children have the same rights to health, development, education, and life as their healthy counterparts, they have a bigger chance to lose their life before even being born, or to be abused or exploited. Inclusive education, as it was also mentioned before, is far from being reached when 2 education systems exist parallelly, one of mainstream education and one that is called special education, when in reality it's rather segregated. The right of children with disabilities to spend their childhood in caring and loving family environment is harmed by institutionalization in a tended manner. So from a Hungarian perspective, the invisibility of children with disabilities is striking as well. It derives less from the lack of legislation. Obviously, in my paper I elaborated some possible amendments that could provide a more caring legal environment, but the deficiencies actually come from lack of the number of expertise and the false practice. The fourth finding would be that if we have the child rights glasses or the child rights approach, but implementation and national implementation is really a key. So the implementation on national level should be in line with the international binding obligations, so the wording of the treaties. For the genuine approach, there is a necessity of a very deep understanding of the target group, which in this case are children with disabilities, and the necessity of a tailored strategy in line with the principles that I have mentioned before. And apart from legislative measures in this strategy, we need human resources and financial resources policy and a monitoring and evaluation procedure periodically. From the perspective of Hungarian law, the implementation could be strengthened by underlining the participatory rights of children, so their voice, by including the right to be heard on a constitutional level, such as it is done in Polish legislation. Review the translation of the UN Convention on the Rights of the Child. It was done 35 years ago, and the practice shows that the translation needs some amendment. And as such, the implementation of the Child Protection Act, in order to have a wording that reflects more precisely on the actual meaning of the given provisions, to initiate a rights-based strategy. Currently, we do not have a children's rights strategy, where the child rights-based approach is applied comprehensively. It should consider the 4+1 principles of the UNCRC, and in particularly should support families of children with disabilities, including through financial services, increase access to community services that are inclusive of children with disabilities, conduct awareness-raising campaigns, collect data periodically. We have very few data on this group now, and update this database regularly so it's accessible to practitioners, and involve children with disabilities and their parents of children with disabilities. And last but not least, it will lead us to the last but still not least finding of my research, to appoint a separate institution that would specifically deal with the protection and promotion of children's rights as a main stakeholder of the shaper of the rights-based approach. So it's a National Human Rights Institution as shaper of child rights-based approach. Actually, in my researches, it pops out very naturally that there is an importance to have an institution that has a collective knowledge on children's rights, and also concentrates on the rights of children with the periphery, with an appropriate mandate, powers, trust of the society, who can reach local communities. Specialized national human rights institutions have the chance to complete an interdisciplinary task in this field and act as national shapers of child rights-based approach. Nevertheless, it is important to highlight that no size fits all, so it has to be evaluated very carefully what fits into the national legal system, and adjusted and pasted with a child-friendly manner. In my paper, it's written down in details what are my ideas on that. As a closing remark, let me refer to children being the stakeholders of a genuine child rights-based approach. until a certain age, a child sees no disability but the characteristics that truly shape a person's personality, such whether they like spaghetti or they are more like a steak person, whether they are friends with Emma or Anna. But at a certain age, it starts to change as the society affects them more and more, which means that it can be changed backwards. If we have founded the general legislative background to treat each and every child with the same approach, why not to make the effort to turn it into reality for them as well? Thank you very much for your kind attention.
Thank you, Doctor, for your findings. I fully agree. The last member of our research project is Dr. Paweł Zając from University of Łomża with the subject on ensuring social security of children with disabilities as a challenge for the Polish legislature.
Thank you very much. First of all, I would like to thank to all organizers for possibility to be a part of this project and possibility to work with such distinguished researcher. Today, I would like to talk about ensuring social security for children with disability as a challenge for Polish legislator. One of the fundamental functions of the state, understood as a political, sovereign and territorial organization, is the social function, consisting in guaranteeing the necessary assistance to individuals who are unable to provide themselves with appropriate conditions for existence. This task grows into one of the most important resting on public administration bodies. In the doctrine, it is connected with the category of social security, derived from the constitutional value of state security. Its essence is revealed through all manifestation of activity of the state, society and individuals aimed at ensuring proper and sustainable human development by eliminating process, phenomena and factors hindering its achievements. Social security will therefore be related to ensuring the so-called minimum standard of living, one in which the basic needs of individuals are met: food, clothing, healthcare, education, as well as access to communication or public transport. States implement social security through their social policies, which, despite general common assumptions, cannot be fully compared because they are conditioned by factors specific to a given country. Among them, the most important is the issue of financing and obtaining funds for specific social benefits. A social group that requires special care from the state, becoming a beneficiary of broadly understood social security, are children with disabilities, whose number, both in Poland and around the world, is increasing year by year. This is one of the characteristics of modern civilization and the changes that have taken place in the last century. Advancement of knowledge and medical technologies, extension of human life as a result of the implementation of public health management mechanism and general increase in prosperity, as well as cultural changes relating to health, physical and intellectual fitness and social role patterns. Despite the fact that the situation of this social group has improved in recent years, it is still not satisfactory. It still struggles with barriers and consequently with social exclusion. This topic is very often discussed in the public debate on the demographic condition of Poland, which emphasizes that children with disabilities are seen as a chance for the socio-economic development of the country and, above all, a chance for a changing in social relations. However, in order to achieve these goals, appropriate legislative action should be taken to improve their situation and create a coherent support system that would ensure their full participation in social life. Legislation in this area should be clear, precise, coherent, and inclusive, which results from the basic principle of legislative technique as well as international obligation, Convention of the Rights of Persons with Disabilities and the Convention of the Rights of the Child. The Polish authorities, recognizing the issues related to the functioning of persons with disabilities, as well as their role in the strengthening the potential of the Republic of Poland, adopt as one of the pillars of the implementation of national security the postulate of extending support for persons with disability and dependent as a part of the improving social integration and ensuring access to public services with appropriate standards. Thus, the issue of disability has become one of the determinants of the state security. It also defined a legal framework creating a social security system, the aim of which is to support people with disabilities, including children and their guardians, in ensuring that they met their basic existential needs and those ensuring their proper development. Analyzing the system, which I tried to throughout the duration of the project, analyzing the right to healthcare, to social protection, to participation in the cultural life, or legal protection in cyberspace, or armed conflict, based on concluding observation on a report of Poland issued by the Committee on the Rights of the Child and Committee on the Rights of the Person with Disabilities, it can be concluded that the social security system of children with disability in Poland, to a greater or lesser extent, fulfills its basic role. Does that mean it's perfect? Absolutely not. Can it be better? Of course. But it will require specific action not only at the legislative level, but also a change in mentality among the entire society. Among the main challenges faced by the legislator in creating a coherent system of social security for children with disabilities is a change in the paradigm of understanding the concept of child with disability. In the Polish legal system, a child with disabilities is considered to a person who is under 16 years of age and has impaired physical or mental capacity for an expected duration of more than 20 months due to the congenital defect, long-term disease, or damage to the body, necessitating the need to provide him with complete care or assistance in meeting basic living needs in a way that exceeds the support needed by a person of given age. This definition does not coincide with the definition of a child contained in Article 1 of the Convention of the Rights of Child, or even in the definition from Article 2 of the Act on the Ombudsman for Children in Poland, according to which a child means any human being under the age of 18. Moreover, the concluding observation on report of Poland issued by the Committee on the Right of the Child and Committee on the Rights of the Person with Disabilities emphasized that this definition divides from the proper understanding of the concept of disability, distorting its content by referring only to the medical understanding of disability. According to CRPD, children with disabilities include those who have long-term physical, mental, intellectual, or sensory impairment, which interaction with various barriers may hinder their full and effective participation in society on an equal basis. Such a broad approach allows including in this group children who are born with a genetic condition that affects their physical, mental, or social development, those who sustained a serious injury, nutritional deficiency, or infection that result in long-term functional consequences, or those exposed to environmental toxin that results in development delays or learning disabilities, or those who develop depression as a result of stressful life events. Moreover, the definition of children with disability is not compatible with the definition of disability contained in the Act of Vocational and Social Rehabilitation and Employment of Persons with Disabilities, according to which it means a permanent or periodic inability to fulfill social roles due a permanent or longer-term impairment of the body's abilities, in particular causing inability to work. The lack of definitional uniformity and the restrictive interpretation used by Polish legislator mean that this definition does not fulfill its inclusive purpose. On the contrary, it is exclusionary and stigmatizing. Similar objections were raised in 2022 to the definition contained in Hungarian law. A good example in the respect may be the inclusion definition adopted among others by the United States of America, Germany, France, or Great Britain. Another challenge is the comprehensive reform of the disability assessment system. There are 6 disability assessment systems in Poland, 4 regarding entitlement to disability benefits, the 5th, the degree of disability, and the 6th, special education. This makes it necessary to undergo tests by various expert teams that take into account various aspects of the health conditions. A reform in this area has been announced since 2016, but today we have not seen comprehensive solution. In 2023, only regulation will enter into force that will add to the existing 3 degrees of disabilities, degrees that will determine the degrees of difficulty in functioning independently, which is intended to individualize support to distinguish people who require the most extensive package of services. The qualification will be based on a systematic diagnostic procedure developed separately from person under 18 years of age and person over 18 years of age. However, we must wait to evaluate this system. Challenges also include the process of eliminating all negative terminology in all existing and drafted regulation and replace it with terminology that fully respect the dignity and autonomy of children with disabilities, strengthen early identification of disability and age-appropriate rehabilitation intervention, improve informational outreach for parents of children with disability, and develop programs to support children with disabilities in transition to adulthood to help them to start an independent life. Organize the systematic and comprehensive collection of data of children with disabilities, including disability as a discriminatory ground in the crime of hate speech, or codifying the crime of cyberbullying in Polish penal code, which would ensure greater protection of children with disabilities online, or changing the foster care model, which involves moving from institutional care to care provided in a family environment. The presented issues are only a fragment of a large whole that ensures social safety of children with disabilities, which, however, require changes and adaptation to international standards. In conclusion, it should be said that the social security of children with disabilities should become one of the priorities of the social policy of each state. Because without making our society inclusive, sustainable, and resistant, children and adults with disabilities cannot fully realize the right to ensure the full enjoyment of all human rights and fundamental freedoms on an equal basis with other children. Adopting an effective social policy towards children with disabilities is not a handout, but a sign of our humanity. Thank you very much for your kind.
Thank you, Doctor, and thank you all professors for your excellent lectures you gave. Now we can start with the discussion, but let me ask Mr. Tomasz Jastrzębski to share with his remarks. Please, Doctor.
Thank you very much, Mr. Dean. Ladies and gentlemen, as a discussion, Professor said, I have a question for you. Think about your lifelong experience and ask me the question, have you ever used in theater during abstract, in the airport, at the airport, when you're in rush, in museum, a restroom with a sticker in label with a man on wheelchair, a toilet for disabilities, the people with disabilities. Did you?
Yeah.
Why you did it?
Because I was disabled at the time.
Okay. Any other answered? Yeah, you were in rush. Yeah. Usually the answer is there was a short queue. Yeah. Did you think about the people who are not in rush like you and need that toilet and need more time there to use it? And second question is for the experts, was it legal?
Yes, I think yes.
Yeah, of course it was. It depends of our attitude, of our behavior, and it's part of our human behavior, so it's of course legal. I ask you that question because I'm going to, as Kasia said, do remark, and at the beginning of our meeting today, Professor Szilagyi brilliantly said that internalization, translation, unification, it's much important, very much important, but with awareness and with consciousness, because in not each part of our life is that easy. For example, me, I represent here a minority, because I'm not a lawyer, within lawyers. So I'm appreciate and I'm honored, I was honored to listen you and be part of, as an audience, of course, during your meetings each second, I remember Thursday each month, and I listened to your, I had a kind of crash course of law, and me representing medical sciences, and I'm glad, and if you allow me to share your conclusions before paper, I'm doing as fast as soon as possible during especially the Congress of Public Health we have in 2 weeks in Wrocław in Poland, because your job you did, you show it's law, it's not for lawyers. It's extremely important, and I'm glad you see the problem, and you did your job. And as the last sentence, I would say, I would repeat what Marta said at her conclusion. People with disabilities, children with disabilities as well, have special needs, of course, but the same rights have, definitely. So that's from me. If you have any comments. Thank you.
Discussion? Zapraszamy do dyskusji. We still have a while, yes. Maybe there are any questions or someone want to comment? Part one. No? So I pass the floor to the organizer.
This is Professor, thank you very much. And in this time we have a very celebrated moment because we give the certificate to attendance and achieved at this program. And so it is, maybe I show, it's a special handmade certification in the wood, ecological. Individual pointed out this participant. So Profesor Katarzyna Olszewska. Kasiu, bardzo dziękuję za wszystko. Dziękuję bardzo.
Thank you very much. I'm very grateful.
Pan profesor Wojciech Lis. Pani doktor Marta Beniusz. I pan doktor Paweł Zając. Gratulacje. So, the last word, Mrs. Professor.
So, thank you very much. Thank you for your attention and taking your time. And now I think we can close part one and start lunch. Thank you very much.